The care plan is an important component of this. Justice and Aging, again, the advocacy group, urges consumers to be determined in seeking individualized care from the facility, because they say the risk of retaliation is relatively small compared with the risk of being passive. You're passive, you're going to be evicted. They're advocating the consumers to participate actively in the development of a care plan. And once the care plan has been established, you can use the care plan to ensure that the facility provides all necessary care as spelled out in the care plan, and use it as a defense against an improper eviction. So many times in an eviction, the nursing home complaint is that it has a difficult resident, and the materials all say that the problem of having insufficient staff to meet the residents' needs is something that should not be accepted as a justification for an eviction. Some nursing homes try to evict the resident who tends to wander or who has severe dementia, makes sounds at night, and they're usually always improper because a nursing home is an appropriate placement for someone who has dementia. And a can't meet your needs eviction is only valid if the care needs can't be met in the nursing home in general. In other words, if you need a locked unit sometimes, some facilities don't have that. Something special that makes this dementia patient unique. Oops. Let's see. And here's justifications for improper justifications for eviction. The resident is difficult, requires too much staff attention. The care is too costly. The caring prevents, the level of care prevents the staff from attending to the needs of other patients. The resident requires a two-person assist. Resident doesn't follow the nursing home's policies. You hear all of these quite a bit, and they don't really justify the proposed eviction. When a facility claims that a resident's needs can't be met, rather than accepting it, the resident should stay, request a hearing, because you do have appeal rights, and appeal the proposed eviction. You can't be evicted while the appeal is pending. The eviction of difficult residents is often based on the resident's welfare, and that the resident's needs can't be met at the current facility. And along with the materials I cited in that paper is one commenter that said that this type of argument only applies if the resident's needs can't be met in any nursing home. This is important, I thought. A facility is now required to disclose and provide to a resident or a potential resident prior to time of admission notice of any special characteristics or service limitations of the facility. And if it fails to give you those limitations, then that should prevent a later claim that it can't provide the necessary services to meet the resident's needs. So Linda spoke about the individualized care plan. The revised CFR provisions regarding the rights of residents in the development of a care plan. A personalized care plan is an important element to an eviction challenge. before the facility proposes an eviction, it must first attempt to meet the resident's individualized needs by developing, implementing, and modifying as necessary the individual care plan. So here's some of the reasons that they give just to try to justify an eviction. Inadequate staffing. Inadequate staffing is the facility is required to assess what staffing is necessary on a day-by-day basis and in emergency situations to care for its residents. So it's supposed to take into account the people that it has and the care needs of every person, including the types of conditions, the disabilities, and other factors presented by the resident population. According to the CFR, the facility must have sufficient nursing staff with the appropriate competencies and skills to provide nursing and related services to assure resident safety, and attain or maintain physical, mental, psychosocial well-being of each resident, as determined by the assessments and the individual care plans. The documentation of unmet needs. The CFR provides that a resident's physician must document the specific resident's needs that can't be met at the current facility. Again, the attempts to meet those needs and the services available at the new facility. And the failure to comply with the documentation requirements should lead to a successful challenge to an eviction or a transfer. If the facility doesn't have the documentation, it can be used to challenge the basis for the attempted eviction. Then there's a whole group of requirements of just the transfer notice. We've had cases like this where they just don't provide all the information that's required in the regs, and you can stop the transfer, or at least delay it. You have to get before a court or an administrative law judge. This is one way to stop it, because these notices are, the ones I've seen and been involved in, they're deficient. You gotta give 30 days notice. You have to put down the reason for the transfer or the discharge, the effective date, where the resident's going to be discharged. You have to give the resident appeal rights, and where you file that appeal. Name, address, telephone number of the office of the ombudsman. This is where I met Bill, by the way, trying to stop one of these transfers. How many years ago, I don't want to say. Let's see. Here's all the slides have all the things that you have to be on. It depends on the resident. If you have developmentally disabled resident, you have to have that agency's contact information. You have people with mental disorders. You have to have the appropriate agency's contact information on the discharge notice. And this, insisting, just the simple fact of insisting that the notice meets all the requirements can buy the resident some time. And these are the easiest thing, because you're not going into the merits of what they're doing. Just saying, hey, you're supposed to give them 30 days. You can't just discharge them. Or where's the appeal rights? They have to resend the notice. Might get an extra 15 days, an extra 20 days. That's what you're looking for, because you have to, you have to file an order to show cause. You have to get into court somehow. You have to involve the ombudsman. Sometimes they'll give you some assistance.